Happy New Year, everybody. Richard Seller here with a new video for 2018. I want to start off with a confession. I generally start my videos by saying, I'm dressing down in the office today. If I'm not meeting with a client or a lawyer or I'm not going to court, this is how I dress. I wear a lot of Miami stuff. I love my Miami Hurricanes. You all know that by now. But in any event, I feel a lot better to have gotten that off my chest. I wanted to talk to you a little bit about what I call the stacked deck. And here's what I mean. The courts and the legal system are set up for employees to fail. And there have been studies done that say statistically, out of 1,000 employment lawsuits that get filed, less than 3% of them actually find their way to a jury and wind up being monetized at the end of the day. Because, as I'll talk about a little bit, the system is stacked and set up for the judges and the employers to get these claims dismissed on technicalities, things that we call summary judgments, where at the end of the what we call the discovery phase of a case, an employer will file a motion with the court saying, even though we exist in a legal system where there should be jury trials, judge, there's no reason to send this to a jury because we're right. The standard is there's no issue of fact that needs to be decided. Now, think about that for a second. The right to a jury trial is one of the most important rights in our civil justice system. But if you take a look statistically about what happens in employment lawsuits, the majority of these cases in federal court get taken away by a judge, and clients never even get to see a jury and have their day in court. And it's a pretty scary process if you think about it, because let me tell you why. Juries of our peers are the ones that are supposed to be deciding cases. If I say the light was red and you say the light was green, a judge that's appointed by the United States, that's generally along party lines, and I will say notoriously that the Republican judges, and I'm not bashing or political bashing here, are very pro-business and wind up getting rid of these cases very quickly, whereas a left-wing or a liberal judge is more likely to say, let these cases go to a jury without me deciding. But imagine how unconstitutional it is that you're entitled to a right or a jury trial by right, but that gets taken away by a judge who's been sitting on the bench for years and who essentially goes unchecked. Because remember, federal judges are appointed for life, which means they're not influenced by voters, they're not influenced by anybody else. So they make decisions on islands, and they take these cases away from plaintiffs repeatedly. And then you have employers these days that are making employees sign arbitration agreements. And most employees don't even know what they're signing. When they go to work and fill out an application, oftentimes there's a little box at the bottom of the application that nobody ever reads, which says, by agreeing to work for this employer, I'm giving up my right to go to a court, and instead my claims have to be decided by an arbitrator. Guess who's paying for the arbitrator? The person deciding your claims. You guessed it. The employer. So what happens is you're now not even entitled to go into a courtroom. You've got an arbitrator, a person who's assigned by the AAA, which is the American Arbitration Association, or these other services, to decide your case. Now, this arbitrator gets paid by the hour to decide your case. And again, guess who's paying the bill? It's the employer. So the arbitrator generally doesn't want to upset the employers because they want to get another arbitration from the employer. So guess how that generally works its way out? Stacked deck. So think about this. You're saying to yourself, well, Rich, why even try? And I'll tell you, doing what I do can really be a blessing sometimes, and it can be very frustrating sometimes, because think about how hard it is, okay? I'm not crying poor me. I'm saying how hard it is from the perspective of an employee. Your employer does something negative. Let's say he makes a racist remark in the workplace, okay? And you say, hey, you can't say that, and then he turns around and he fires you, okay? You then go ahead, you retain me, we file a suit, and the employer gets all of your former employees together in a room, because this is what happens, and he says, I need all of you to give me a statement saying that I never said that. Now, you still work for this company. Do you have the guts to stand up to your boss and say, I'm not signing that? And the answer is absolutely not. Most people don't. It's very rare that you'll get a current employee who will say, this is wrong. Because people are what we call job scared. And it's a scary situation. So now by the time we go to court, I've got 10 statements from employees who still work for the company saying that what we claim never happened. This is why I always tell my clients, and this is why I'm always telling you folks, first of all, read what you sign when you start a job, okay? Read what you sign. If you don't agree to arbitration, there are a lot of procedures for most companies that allow you to what's called opt out of arbitration. You do not want to be in arbitration if you don't have to be in arbitration, okay? Step 1. Step 2, you've heard it before. Document, document, document. If something is going on in your workplace and you're relying on your memory or what you're going to say verbally compared to what the employer is going to bring in with 10, 15 witnesses against you, because nobody's going to stand up for you unless they're no longer there. And by the way, if they're no longer there, guess what the employer calls them? A disgruntled employee, right? The only reason they're supporting you is because they got fired too or they're no longer at the company. But going back to document, 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 when something is happening in the workplace, create a record of it. Either it's a journal or a handwritten note or something that you can go back to in case litigation is ongoing that says that at the time this happened, you weren't making it up. You wrote it down. You can send an email to yourself. But if you're not documenting your cases, if you're not documenting what's happening to you in the workplace and you're assuming that a jury or a judge or an arbitrator are going to do the right thing, don't take my word for it. Look at the statistics on it. And it's a scary proposition. We wake up every day and we fight for folks. We go against a stacked deck, and that's what we do. And it can be very rewarding, you know. But just as an example, a couple of years back, we recovered a verdict for in excess of $1 million at a jury trial where a jury decided in favor of our client. I believe the verdict was $1.3 million. The employer appealed. Guess what the appellate court did? They took the complete verdict away from my client, and then they entered a judgment against the client for about $40,000 or $50,000 that he had to pay the other side's costs. How do you explain that? How do you reconcile that, where a jury of your peers found that the employer violated the law and judges took it away? So this isn't a gloom and doom session. It's just I've been thinking a lot about it, how unfair the system is. How do we change it? It starts at a local legislative level. It starts with doing what you need to do as an employee to protect yourself. You're up against a stacked deck, but do everything you can. Everything you can. Witness statements. Read what you're signing. Document, document, document. And give yourself a fighting chance. And as you know, we always say to you, if something's happened in the workplace and you believe you've been wrongfully terminated, fired, demoted, discriminated against, not paid properly, whatever it is, email us, call us. We'll take a look at it. But help me help you, quoting Jerry Maguire. How's that? Anyway, Happy New Year. Let's make it a good year. A lot of gloominess going on in the first couple weeks of the year. It's tough to get going, tough to get back to work. Let's do it. Let's have a good 2018. Let's protect you. Let's protect your families. And let's level the playing field as much as we can. Have a great day, guys.